Hey guys, today we have on the show two drone attorneys talking about how patents can help drone companies make more money and protect their technology and ideas from being stolen.
Hi, my name is Vlad Shvartsman. I'm a patent attorney, and I'm going to be speaking with Jonathan Rupprecht, who is a drone attorney and a commercial pilot with a single engine, multi-engine, and instrument ratings. He's an airplane flight instructor and an instrument flight instructor. He's been on Newsweek, Politico, NPR, Marketwatch, The Independent, Motherboard, and many other sources. He obtained his BS from Embry-Riddle Aeronautical University, Magna Cum Laude, and a JD from Florida International University School of Law. He also authored a book on drones, their many civilian uses, and U.S. laws surrounding them. He was an advisor for one of the amicus briefs of the highly publicized Huerta v. Perker case, and he co-authored a legal treatise on unmanned aircraft, which is being published by the American Bar Association. Jonathan currently practices drone law in South Florida at his firm Rupprecht Law PA, which can be found at jrupprechtlaw.com. And he's helping out with big cases right now in Taylor versus the FAA, where there's a challenge to the FAA flight drone registration rules.
Hello, my name is Jonathan Rupprecht, and today I'll be talking with Vlad Shvartsman. Vlad's background, he's been involved in patents since 1989. He has been practicing patent law since 2001. He deals with drone technology and has been doing that since 2013. He is an avid hobby flyer and RC helicopter flyer of RC helicopters and quadcopters. He curates a blog with the latest drone patents and patent applications since early 2015, and that blog can be found at uavpatents.com. So with drone technology, it's growing exponentially. Every component from plastics used for the propellers to autonomous navigation to better motors is experiencing stellar innovations. Coupling new developments with the FAA's imposed regulatory conditions, drones will never cease to really evolve.
That's right, Jonathan. We are right now witnessing the birth of a massive, massive industry of drones. And the leaders of this industry will cement their place by always continuously improving the concept of the drone.
Vlad, in your patent research, have you been able to determine who is leading the pack?
It's funny, I see some astonishing related inventions to drones. Of course, there's the usual big players like DJI, Unique, and Parrot, but there are also smaller players emerging with some phenomenally interesting technology. So the field is still growing. It's very difficult to say who's going to be leading the pack. It's a question of time.
Now, Vlad, why would a company decide to pursue a patent?
Well, it's a very simple answer. If you boil it down to the end of it, the answer is money. You can make more money with a patent. You can leverage your patent to make more money, and you can stop others from selling your product, meaning that you're going to make more money.
Now, how does a patent improve, your revenue stream?
Well, with a patent, you can be the only company that can sell a particular product. The patent gives you a right to exclude others from the marketplace. You can also license your innovation and get a royalty for the license based on a percentage of the gross revenue of whoever you're licensing the patent to.
Okay, fair enough. But what exactly is a patent?
A patent exactly is a right. It falls into the category of intangible property. On the balance sheet, you have tangible assets and intangible assets. So the patent is an intangible asset, but it is still property. Make no mistake. You can give it a value. You can license it. You can sell, bequeath, depreciate, just like you can do any other property.
Now, when you say right, now do you mean something like an easement?
That's right. It's like, for example, if you buy a piece of land near a lake and you want to cross your neighbor's property to the lake, well, sometimes your piece of property will come with what's called an easement, meaning that your neighbor cannot stop you from crossing his property. So this is exactly like a patent. It's a right to exclude others.
So suppose I'm a manufacturer of drones or a component that goes into a drone, and after much research, I discover a way to do something better than before. Do I get a patent automatically just by discovering it?
Well, that used to be the case. For example, in the days of Bell, when Bell patented the telephone, he just filed for a patent and he got his patent. Today, it's a little bit more complicated. The first thing you want to do is make sure that you do not tell anybody about your discovery.
Not tell anyone. Well, why not? I mean, what about if I tell my wife or kids, or what happens if I do tell somebody?
If you tell somebody, you could lose your right to patent your invention. In the United States, you have 1 year from the date of telling someone to the date of applying for a patent. If you miss that 1 year deadline, your invention will be deemed by law to be public domain. So you're basically surrendering the invention to the public. However, in Europe or in China, there is no such 1 year grace period. And if you tell somebody without a patent application, you may lose your patent further down the line.
So in the US, you have that 1 year before you must file for a patent.
Today, yes, but there are rumblings from the USPTO that this 1 year grace period is going to be removed just to go in line with the rest of the world. And that means that you should not tell anyone, even today, you should not tell anyone of your invention should you decide to pursue a patent for it.
Now, keeping your invention secret until you file an application, it seems to be the safest way to go.
That's right. Unless you're comfortable with releasing your invention to the public domain and letting others profit from your discovery, you should not tell anyone.
Now, what if I'm not comfortable with giving up my rights to protect my invention? What is the first step to getting a patent?
Well, the first step to getting a patent is to do a patent search. First, you have to make sure that nobody has discovered your innovation before you. The US Patent Office has a free online patent database, and it's relatively easy to use. You can do your own search or hire a patent firm like my firm to do a search for you. You should keep in mind that no search is ever complete. A patent application remains classified in the US Patent Office for 18 months from the date of filing. So if you do a search, make sure that you keep in mind that you are not doing a 100% search. My blog on the latest patents applications has a lot of material, but is not exhaustive.
Do you have a tutorial on patent searching?
I can provide you with a tutorial if you ask me nicely.
Okay, so we've done a patent search. Now what?
Okay, so we look at the closest patents that we find in the patent search. Keep in mind that there are very few pioneer inventions, meaning that every invention is an improvement of something that came before. So what we're looking for is the improvement that came last, and your improvement should be better than the last one. If your improvement has already been patented, it is not worthwhile to pursue a patent. In fact, you may also need to seek a license from the patent holder if you want to manufacture your invention. But that's another blog.
Now, suppose all the patents and applications you discover in the search are inferior to, my invention. Have I really invented something? Let's say I have actually really invented something new. What should I do next?
Well, if, for example, we find something that is inferior to your invention, but nothing on point to your invention, it is time to make a big decision. So, depending on how much money you have and your market position, you have three options. First of all, not pursue a patent at all. If you can sleep at night knowing that you can be copied, just forgo the expense and let it slide. Your second option is to file for a regular patent application. It takes at least 4 months to get all the details out of your invention to write up a proper application. The third option, if you're in a rush, if you're in a bind, if you need to go see venture capital really quickly, you can file for what's called a provisional patent application. The provisional can be prepared in a matter of days and gives you a 1 year grace period to file for a regular application while keeping your provisional's filing date.
Now, let's assume I'm a smaller company with limited resources. What do you think would be the best option for me?
In our practice, we usually recommend the provisional. It will give you essentially a non-disclosure agreement with the world. You will be able to tell everyone. You can tell everyone about your invention without fear of having it taken away from you. You'll be able to claim the coveted patent pending status, which is very good for marketing purposes. And you can look for angel capital, crowdfund, or go to trade shows. You will be able to get a feel whether it's worthwhile to pursue a regular patent application, all the while you'll be protected.
Now, how much does it cost to file for a provisional patent?
You can do it yourself, but our firm can prepare a provisional patent application anywhere between $1,500 and $3,000, depending on how complex your invention is.
So I'll have 1 year of that patent pending status to get feedback from the world. Then what? I have to file for like a regular patent application or something like that?
That's right. You have 1 year from the date of filing of the provisional to file for a regular application. But keep in mind that it takes a good 4 months to prepare a proper regular application. So essentially you'll have 8 months.
That's not really that much time.
No, 8 months is actually going to fly by really quickly. And this means that before you file the provisional, you should get all your marketing material prepared before we file the provisional so that you can get the ball rolling right away as soon as you get your certificate.
So I have to show the invention, touted it, it's patent pending status, and the feedback is good. The industry is interested in my invention. Now what?
Okay, so the provisional application has been filed. You are getting great feedback from the industry. You are prepared to pursue the regular patent application.
Okay. You mean there's no one patent I can get for just like worldwide protection?
No, you have to go country by country, and you can base every application in every country on the provisionals filing basis. However, there's no worldwide patent. This is a big fallacy people make, is that they think there's one patent that covers the entire world. The closest thing that gets this one world patent is called PCT. But we tell our clients usually to file only in the USA and Canada because you have very good court systems. If you can afford it, you should add UK, France, and Germany. If you want to go to Asia, Japan, and perhaps China, although we're still not quite sure how efficient China is for patent protection.
Understandable. Now, how much does it cost to file a regular patent application?
Well, again, it depends on how complex it is, but professional drafting fees for a regular application start at $3,000. Everything together, all the fees, including the government and professional filing fees, you should be budgeting around $7,000 to $8,000.
Okay, and then after that is, once again, when that's filed, what happens next?
Well, the application will go into what's called examination. So you'll have a patent examiner looking at the application to see how much innovation there is compared to the previous applications or patents. This may take a year or two because there's a line of many patent applications in the U.S. Patent Office. They can't handle it fast enough.
Okay, and then what's the time frame on that and the costs?
Okay, so let's say it takes 2 years for the first examination to come around. You will have 6 months to answer the application. Again, it's very difficult to say case by case, but the cost frame is around $10,000, and the time frame is around 5 years, the whole back and forth before you get your patent.
Okay, and then you get the patent?
And then you get your patent. And then you can exclude others from making, selling, or using your patented invention.
Okay, great. So Vlad, if someone wants to get a hold of you to learn more about what you do, what is the best way they can contact you, and how do you get to also your blog?
Well, my blog is www.uavpatents.com. The email is info@uavpatents.com, and you can reach me toll free at 866-550-5505.
All right, Vlad, thank you so much for explaining all this. It's been it's a complex area, but you've helped to educate us further so we know what to do with this information so we can make money and protect our interests and ideas from being stolen. Thank you so much.
Thank you very much, Jonathan. It's a pleasure to speak with you.
It was a pleasure to have you. Bye.